Good morning, Liberty. It is Monday morning, March 4th, 2019. My name is Michael Boldin, broadcasting live through the 10th Amendment Center's YouTube channel here from my home office and studio in downtown Los Angeles. I'm very grateful for you spending a little time with me today, whether you're watching live through the live stream on YouTube, or if you're watching later on in the archives, today, tomorrow, next week, next month, whenever it happens to be, if you're listening to the podcast, it doesn't matter. I think it is really amazing that you find it interesting enough to join me for a little chat. Now, today's show, I want to talk about Constitution Day. I know in the past, I've done an episode in regards to September 17th. That's the unconstitutional federal mandate for unconstitutional public schools to teach about the Constitution, which is kind of an absurdity if you think about it. But today, we're commemorating when the Constitution itself went into effect, not just what happened at the Philadelphia Convention, because as most of the founders taught us, and that the legal basis, now the Constitution is in of itself a legal document. So what gave it legal force isn't the goals or the intention or the conversations of what happened in Philadelphia. It isn't what was said in the Federalist Papers. It isn't what was said in the so-called anti-Federalist Papers. But what gave it legal force were the state ratifying conventions, because the Constitution didn't come into effect without getting approval by a requisite number of states. And how they understood the document to mean, some of them had good legal understanding. Some of them had good public general understanding, and sometimes it conflicted. But how those people and how the ratifying states understood the document is what gave it legal force. And today, March 4th, is the day that the Constitution went into effect. Now, before doing that, I do want to get a quick hello into a number of great friends that I see so often out in the live chat. And actually, a few new ones, some members from the 10th Amendment Center membership program, a bunch of awesome people here. Richard Robertson, Bob Brewer, Tyler, Ward Lawrence, Existence, Ralph Stone. I don't know if I've seen that name before, but good to see you, Ralph. Larry Clark, good to see you as well. EHP Training says, nullify everything. That's a good motto. I often think, if the federal government is doing 90 to 95%, if 90 to 95% of what the federal government does is not within the bounds of the Constitution, a knee-jerk reaction to every federal program of nullifying it or rejecting and resisting it means you're going to be on the winning side most of the time. I think I said hi to Tyler, Woodsider, Anna Rays, and everyone else who's joining me. Even if you're just watching in the background, not leaving some comments, I'm very grateful for you spending some time with me today. So let's get into it. I think this is probably going to be a relatively quick show. If I'm having any technical issues, please let me know. I'm having to switch over to a new YouTube live studio dashboard because the current one for the last hour or so has been giving me this internal server error, and every now and then I'll get that in the dashboard and on our channel. But it usually goes away within a couple of minutes. So I'm having to use their new studio. So if there's any issues, please do let me know. I'll try to keep an eye on it. Even if I can't during the live stream, I'll look back at it later. And if I need to, I'll do some tests to try to resolve any issues that might be coming up. So let's get into it. I want to actually point out two previous podcasts I did. I mentioned already in the intro here, is Constitution Day a scam? Good Morning Liberty was our episode on September 17th, 2018. And that's where I basically go over the idea that a federal mandate to unconstitutional government schools that are funded by unconstitutional federal funding and unconstitutional federal taxation, that in and itself creates a problem, because then you have the wrong people basically teaching about the Constitution. And then, of course, when the wrong people teach about it, people are going to get the wrong foundation. So that's a very interesting episode to go back to. And of course, all the links that I'm going to attempt to talk about, and maybe the ones, I'll mention a few others, but I generally try to include the links in advance in the show notes here on YouTube. And then, of course, I do also have all the archives over at 10thamendmentcenter.com/goodmorningliberty. Richard Robertson is correct in the comments here, and I'm going to get into this as well. It wasn't any state government body. When we refer to the states, James Madison, for example, mentioned this in his famous report of 1800. In this referencing of the states, in talking about the ratification of the Constitution, it is the people of the several states. And I should actually be more clear about that. So I thank you for mentioning that, Richard. The people of the several states. So when the states ratified, the people of each state gave it their voice, or through their representatives, through the conventions. The other podcast that I want to mention that I did was back in February, just last month, the Supremacy Clause Smackdown. I'm going to briefly talk about some of the history leading up to the ratification. That was in an article that we published this morning by Dave Benner, who's just an awesome historian and a friend. You should definitely follow his show, his podcast, and the like. But Dave talks a little bit about the New Jersey plan and the Virginia plan, and I get into that in more detail in regards to the Supremacy Clause, some of the history of those debates in the convention. So that's another one that I also recommend that you go back and listen to if you haven't yet. So let's get into Dave's article here. Today in history, the general government inaugurated under the Constitution. Now, the founders didn't think of it as a central government. They often didn't call it a federal government. They called it the new general government. It was there for general purposes, very specific delegated general purposes. And then, of course, those reserved to the states and the people were numerous and indefinite. And here's how Dave starts his article. And I'm just going to go through some of the history here. I think it's interesting. And then I also want to talk about another piece of the puzzle, the foundation of the Constitution. So today in history, on March 4, 1789, I think that's 230 years ago, the general government of the United States Constitution went into effect. And this represented the end of a bitter ratification struggle. There was a lot of bitterness at the debates in the Philadelphia Convention and then also in the ratification. So some of the things that were changed, and Dave mentions them. For example, Congress now consisted of two houses, one of which was apportioned by state population, with the other comprised of 2 delegates from each state. For the first time, he writes, a federal judiciary was instituted to adjudicate several types of cases, all of which were strictly defined. Now, they think, we don't know that, of course. And then he says, in addition, the new Constitution established an executive department headed by a president of the United States, armed with the ability to enforce the law, establish foreign relations, and execute wars once declared. And so he goes over some of the reasons behind how it got to the point where even supporters and opponents of the new Constitution, they may have been at each other's throats. Most of them were actually still opposed to the Articles of Confederation. He talks about some of the history behind that. And when you read through the ratification debates, and I recommend if you want to get an introduction to this, is a book by Pauline Meyer, who's a deceased historian who wrote a book called Ratification. I'm sorry I did not include the link to that. But you can get a lot of the understanding of the history of how this went down. Even those, in most cases, not in every, but in most cases, those who were opposed to ratification weren't. Today, if you say you're opposed to Hillary Clinton, people automatically assume you support Donald Trump. Oh, well, then you must be on the side of Trump, and vice versa. If you oppose something that Trump does or you oppose Trump himself, then automatically you must be in favor of Hillary Clinton. That is absurd. So many people who were opposed to ratification or didn't like the Constitution repeatedly referred to it as it now stands. That was the phrase. The Constitution as it now stands. Unqualified ratification was what they were opposed to. They wanted changes. Most of them who actually even supported a new Constitution actually just they didn't like the form. They weren't necessarily automatically in favor of keeping the Articles of Confederation. So there's some interesting history that Dave covers there. But getting into the details here of what I wanted to talk about a little bit more, he talked about a number of models that were proposed. And he said that summer, several government models were proposed at Independence Hall. The New Jersey Plan, primarily the masterwork of William Patterson, emulated many aspects of the current system with slight alterations. I think you could actually call the New Jersey Plan more of an attempt to amend the Articles of Confederation. That was one proposal. On the other side, and as I talked about in the Supremacy Clause Smackdown episode, this was the two competing visions that gave us the Supremacy Clause. You had the New Jersey plan, which was basically a total federal system, one state, one vote. It was an amendment to the Articles of Confederation. And then the Virginia plan, which was a centralized power that basically wanted the national government to have a veto power over all acts of the state government. But he also adds an additional attempt that was done in between by Alexander Hamilton. What a surprise. He also attempted in the Annapolis Convention of 1786 to come up with a huge alteration of the framework. He wanted basically a monarchical system. So this is how Dave put it. Hamilton, the arch nationalist, proposed a quasi-monarchical system where the executive would be elected monarch that served for life, where the states would be consolidated into a singular political entity, giving an absolute veto power for the executive over any law, and where state governors would be appointed by the central government. So all those people who love the popular Hamilton and the musical, if you're on board with Hamilton, they never seem to be saying they love everything because they probably don't know the history. Or maybe they are on the side of a kind of pseudo-monarch running things and having that pseudo-monarch appointing members of their cabinet basically as governors of the several states. And Dave also points out that the most famous of all these attempts was the Virginia plan. But the Virginia plan was rejected. This was done by primarily James Madison and Edmund Randolph. Randolph was the guy who introduced it. And he writes, their scheme called for a bicameral legislature with two houses based on state population, a general legislative authority rather than the power to legislate on specific objects only. Basically, the federal government could legislate on anything, and it would have a veto power of any act of the state governments. He wanted an executive appointed, or in this Virginia plan, they wanted an executive to be appointed by the national legislature, a judiciary with the power to take up any case of perceived importance, and Madison's most prized recommendation of federal veto power over state laws. And I've mentioned it on this show and done a specific video on it as well, that Madison specifically wrote to George Washington before the convention started with his ideas, many of which ended up in the Virginia plan. And he was concerned that if the federal government did not have an absolute veto power of any act of the state governments, treating the states like mere political subdivisions or corporations of subcorporations of the national government, that every act of the federal government would be, quote, evaded and defeated. Now, he changed his mind by the time he wrote Federalist 46 as far as the political approach, because he said now at that point this was something to cheer on, the fact that the states could evade and defeat every federal act by refusing to participate in them. Now, he may have still been on the side of that. He still thought it was necessary, but I think he prioritized and recognized that he wanted to get the Constitution ratified rather than this one piece of the puzzle that he didn't get in it. Now, I'm not sure how that all went out in his own mind, but that's how it played out. And so Dave points out that the Philadelphia Convention disposed of almost every nationalist element of the Virginia plan. Instead of two houses based on state population apportionment, the upper house would be equally appointed by each state and have more power over appointments and treaties. He says rather than a general legislative authority, much like that which existed in Great Britain, the Philadelphia Convention arrived upon the enumerated powers doctrine. This is the idea of positive grant. Powers that are delegated are the ones that they can exercise, and everything else, automatically, if it's not delegated, they can't do it. It's held back by the sovereign. The sovereign in the American system is the federal government isn't sovereign, the state governments are sovereign, the people of the several states are sovereign, and they apportion out and delegate out powers to various levels of government as they see fit. Now, the people of each state could change how they want to delegate that over time. He also points out that instead of a powerful central judiciary, the resultant framework provided for a less powerful judicial system where courts only had authority to rule on certain specified cases and where Congress could even eliminate all inferior courts. Madison's cherished veto power was deliberately voted down, much to his chagrin. And I pointed that out in the Supremacy Clause Smackdown episode as well. Madison really wanted this. He told Washington he thought it was an essential defensive power. He didn't get it, and I think he just let it go because he tried, and they think they tried repeatedly, but they voted against this type of a veto power. And then they said, well, the federal government will only be supreme in areas that have been delegated to the federal government. So as long as they're doing things in pursuance of the delegated powers, then its acts are supreme. But they can't not just everything. So by the end of the convention, our good buddy Alexander Hamilton confessed, quote, "No man's ideas were more remote from the plan than his," signing the document with reluctance. Dave says that Madison adopted a similar temperament, admitting to Thomas Jefferson that the new constitutional plan would likely be too weak to survive. And that was one of the greatest concerns. He wanted the central government to have more power, and he saw the states as a problem. And we see a lot of people who support centralization of power, whether it's in the libertarian community, the conservative community, the Democrat community. They think that the way to get their thing done is to have more centralized power. And I think this has been a long time misnomer. It doesn't end up working because every time you give somebody the power to do something you like, you're also giving your opponents the same power to either reverse it or do something totally opposite. So I think Madison was mistaken on that, in my own opinion. I'm thinking that a good, strong central authority to override the states was a good thing. So we know that what Hamilton and even Madison, in many ways, what Madison originally wanted versus what he accepted was certainly different. Now, Hamilton, we know there were many times that he actually argued in favor of what we know was approved in the Constitution, but we know behind the scenes he was lying just to get people behind him. And then very quickly after the fact, he changed his approach on things. And Dave really wraps up this kind of introductory overview. He says, at the state ratifying conventions, again, if we're talking about who gave the Constitution legal force, whatever the founders intended, their founding intent, whatever they discussed, whatever they debated at the Philadelphia Convention, would have been the end there had the people of the several states not given their approval. And even though we know, for example, North Carolina and Rhode Island were independent republics for a while, even after the Constitution went into effect, eventually they ended up giving approval to, they joined the Union. So at the state ratification conventions, those that advocated for the new constitutional framework, Dave writes, guaranteed that the document was one of enumerated powers. And I just want to briefly get to this article written by Ben Lewis some time ago. I covered this in more detail on our Bill of Rights Day episode on December 15th-ish in 2018. So he starts out with this. Thomas Jefferson considered these words, the 10th Amendment, to be, quote, the foundation of the Constitution. Ben says, and I talk about this in more detail in that episode, the 10th Amendment is more than that. It is nothing less than the foundation of the entire American experiment based on the principles of the American Revolution. Jefferson specifically said, I consider the foundation of the Constitution as laid on these grounds. Again, the principle of enumerated powers, the powers not delegated to the federal government, nor prohibited by it to the states, are reserved to the states respectively or to the people. That's the idea that they can only do those things that have been delegated to them, and everything else is held back. Now, just because something's been reserved to the states or to the people doesn't mean that the state government has to do something. It's just up to the people of each state to determine how they're going to handle things. So that is what Jefferson considered the foundation. And I think it's very interesting to actually look into this a little further, because we often talk about that, at least in these 10th Amendment circles, the federal government can only do these powers. And then we look at the delegated powers, and then we understand what the General Welfare Clause, the Commerce Clause, the Necessary and Proper Clause, and everyone says, or the preamble, everyone says that this allows them to do anything they want. And then we debate with them, and we do articles and videos and papers talking about how, no, this is what the founders actually intended for this to mean. This is what the ratifiers understood for this to mean. So that's what the legal force of it. And we talk about it in that framework. But something else we also have to understand is that during these debates, not only in Philadelphia, but in the state ratifying conventions, and then in the newspapers and the essays debating it written back and forth between Federalists and Anti-Federalists, term of art, the debates in the public eye also talked about different things. There was a concern that, oh, this new federal power would authorize the federal government to do blank. And it was far beyond what people knew that it would, at least that drafted it. So they had to go and say, no. These are the things specifically reserved to the state. We know that they had many lists of these things that they said, no, the federal government is not going to touch this. For example, agriculture, for example. So Rob Natelson, my friend, and in many ways a mentor to me over the years, even though we don't agree on everything, we don't agree on strategy all the time, he's always been very kind to me and spent a lot of time teaching me a number of things. He says he has this article, and he's written a number of articles on this over the years. The founders' promises about what the federal government could not do. So not only did they tell us what the specific clauses meant, but they also went out of their way to go through these list after list after list of the things that were specifically going to be reserved to the states. But they said you couldn't actually list everything out because, as Madison put it in Federalist 45, the powers delegated to the federal government under the new Constitution were few and defined, and those reserved to the states were numerous and indefinite. Reserved to the states or to the people, as it says in the Constitution. So and again, that's how Rob starts it out. He says, the Constitution created a federal government with powers that, as James Madison said, were few and defined. Yet today, the feds have their paws in almost every pocket of American life. How did that happen? One reason is that if you don't know much about the Constitution's language, you can misread those few and defined powers to be much broader than they really are. And so during the debates, many of the people supporting the Constitution actually predicted, or even especially opposing, a lot of times the opposition, Elbridge Gerry, for example, talked about how he would agree with an explanation of a particular phrase, but then he said, oh, I'm concerned that it's going to be interpreted wrong in the future. So that was a common type of concern. And that's what Rob gets into as well here. During the debates over the ratifying of the Constitution, its opponents predicted this kind of misinterpretation might arise. That's the fundamental reason they demanded a Bill of Rights. It's not enough, they said, to list what the federal government can do. To make the document clear, you also need a list of examples of what the federal government cannot do. The Bill of Rights was one such list. And few people know this today, there were many others. Now, Rob did a full paper on this called The Enumerated Powers of States. It is linked to in this article that, of course, are linked in the show notes, along with all of our archives over at 10thamendmentcenter.com/goodmorningliberty. So he went through a bunch of the debates and the speeches and the conversations and the state ratifying conventions and the newspaper publishing and the essays and on, and he came up with all these lists that were repeatedly mentioned by Federalist supporters of the Constitution saying, no, these are things that the federal government may not touch. And then he also just last year released a follow-up essay as he's gone through more research in the Federalist Society Review, and he says it adds new lists to the group. The essay is called Founders Interpret the Constitution, the Division Between Federal and State Powers. I think it's just interesting stuff. If you really want to dig into this and really get a good understanding, it's going to take some reading, and if you want to do some reading, that's a good place to start. Now, this is his earlier article, one of his earlier articles that we covered or published back in May of 2015, and he talks about this research paper that he did. And he says the enumerated powers of states listed area after area that the Constitution's advocates represented as outside of federal control. I'm just going to read through this list, and I think it's a good way to kind of sum it up. Training the militia and appointing its officers. Control over local government. Regulating real estate. Regulating personal property outside of commerce. Now, if we understand the meaning of the word commerce, it doesn't mean anything that might affect commerce, how the Supreme Court views it today. He says the law of family and domestic affairs, most criminal law, civil justice between citizens of the same state, religion, education, social services, agriculture, and control of most business enterprises. And now he actually did a lot of the research on this through reading these massive volumes of the state ratifying conventions. And I did an episode a little while back talking about how to best understand the Constitution. You have to go to the original sources. And there is a digital collection of these that you can read through. You can even search through the text, the documentary history of the ratification of the Constitution. So this is It's 70,000 documents. Beginning with the publication of the first volume of the documentary history of the ratification of the Constitution in 1976, editors have been publishing the definitive collection of primary source material related to the ratification debate. So, for example, our friend Bob Brewer out here, who's always been so supportive of the show, who comments often about Article 4, Section 4, I need to do some more research. For example, I want to understand the original legal meaning of the word invasion in the Constitution. I can click through this and I can type invasion and do a search. And then I can go through all the results of all the different commentaries of the Constitution, the debates in New York, for example, debates in New York again, there's debates in Massachusetts, and it tells me all the different places. And then I can read how they were debating the term invasion. I can do that for any term. Now, you may not get tons of results for anything that you want, but this is a great starting point to have a good understanding of how the people of the several states understood a particular term. Now, you tie that in with legal and lay dictionaries of the time, and you can get a pretty good picture of how things were intended to be and what type of legal meaning they had. So that's, I think, an interesting list and, of course, a very interesting approach to understanding this foundation of the Constitution, this 10th Amendment that Thomas Jefferson talked about as the foundation. Not only do we have to look at what we know to mean or what we want to understand each of the phrases of the Constitution, the delegation of powers, if we get into a place where we think, oh, okay, well, the Commerce Clause does allow them to ban a plant like cannabis, even though it was grown in someone's backyard in their own home, never bought or sold, never crossed state lines. They somehow say this is interstate commerce. Well, that doesn't jive too well with the idea that many of the Federalist supporters of the Constitution said agriculture in and of itself would be outside the hands of the federal government. So when Justice Scalia in the Gonzalez versus Raich case took the position that Clarence Thomas thought was absolutely abhorrent to the original Constitution, that the federal government could regulate a plant grown in someone's backyard, 6 plants, not for sale, as commerce, then, well, there's a problem there. Things are not connecting. They're not the same. There's a conflict. So this really just helps us a little bit further in our understanding. I hope you guys found this interesting. I hope you found it insightful. I hope it was fun to listen to. I have not been able to keep up with the live chat. Looks like there's a back and forth debate between Richard Robertson and Lazy Viewer that I am definitely not able to keep up on that. I apologize, guys, but I appreciate you spending so much time, and I appreciate the back and forth. I hope that in the future we can expand on this. I know I've mentioned, and I just wanted to touch on it briefly, talking about the documentary history. In the past, I had mentioned that I was going to be putting together kind of a research guide, so you guys could take any phrase of the Constitution and start doing the research to understand how it was understood, the legal definition of the word at the time of the ratification. Because like any legal document, the words of the Constitution mean today what they mean at the time they were given legal force. That is ratification by the people of the several states. So I'm putting together an article on that. I will do a follow-up episode. A piece of that puzzle is, of course, searching through the ratification debates. I like the approach that Madison takes, looking at what was told to the people was going to be specifically reserved, because that ties into our work here at the 10th Amendment Center and reserving powers to the states or the people, and of course to what Thomas Jefferson called the foundation. Again, thank you so much for spending time with me today. Happy Constitution Day, the real one. I hope you have a wonderful week this week, and we'll see you again on Wednesday and Friday, as we are every Monday, Wednesday, and Friday, 9:30 a.m. Pacific time. And, of course, all the archives over at 10thamendmentcenter.com/goodmorningliberty. I did not mention, but I will just as we close out, make sure to smash that like button, keep leaving some comments, and feel free to send an email over to team@10thamendmentcenter.com. Thank you so much for spending some time with me today, and I'll see you next time here at Good Morning Liberty. Have a great day.